Guedes. Dr. McDonough. As you know, our firm represents the city of Homestead. The city has expressed a desire to submit an amicus curiae brief in support of Miss Fernandez-Rundle's efforts to obtain rehearing or rehearing en banc in connection with the subject appeal. As I understand it, you appeared pro se in the appeal. If I'm mistaken as to this point, please let me know immediately and I will communicate with your counsel. If incorrect, however, I would need to know whether you object to the city's effort to appear as amicus, since I must disclose your position to the court when I seek leave. Please let me know as soon as you're able.
McDonough. Dear Counselor, my consent is irrelevant. I would suggest you go and actually read the federal and local rules of civil procedure, the same way as did I. However, any attempt to delay my proceedings is strongly objected to, and all such efforts will be reported to the media, greatly increasing the negative attention your firm is beginning to receive, and that the state attorney is receiving. Thanks and God bless. Dr. James Eric McDonough. Also known as Doc Justice. P.S. Is Chief Rule still lying and claiming I gave him no documents? That seems to me as the only reason the city would expend thousands of more tax dollars.
Federal Rule of Appellate Procedure 29A2, which governs the filing of amicus briefs, reads when permitted. The United States or its officer or agency or a state may file an amicus curiae brief without the consent of the parties or leave of court. Any other amicus curiae may file a brief only by leave of court or if the brief states that all parties have consented to its filing. I have Miss Fernandez-Rundle's consent. Since I'm not entirely clear what your answer to my question regarding consent was, I will simply quote from your email indicating that your consent is irrelevant when I file the motion for leave. If you would prefer to clarify your position and indicate specifically whether you consent, I will include that in the motion. I also noticed you have copied lawyers on your response. As I indicated below, I corresponded with you directly because you appeared pro se in the appeal. If any of the copied counsel are now representing you in this appeal, I extend my apologies to them and would ask that they provide whatever additional clarification may be appropriate regarding your consent or lack thereof.
McDonough. Read Rule 29B. This is a petition for rehearing. You need leave of court, not my consent. I do not consent to any delay you are attempting to bring, as your clients continue to obstruct my rights. Please provide your bar number so I can diligently research your complaint history. As to your noticing me copying some of my attorneys, they are just there to watch you people trip over yourselves. I am pro se, just like I was the last 2 times I beat attorneys from your firm. Can you provide me with the amount you have billed Homestead to date in your effort here? Thank you and God bless.
Guedes. Dr. McDonough. With respect to your final inquiry regarding billing, I'm considering that to be a public records request. Inasmuch as I only within the last few days began working on a possible amicus brief, we have not yet billed Homestead any amounts for my efforts in that regard. Guedes. Sent from my iPhone, which means there is a good chance I dictated the message. Yes, that explains the typos.
McDonough. Counselor Guedes, thank you for your response to my records request. Why did it take so long? Since we are corresponding via email and you represent Homestead and WSH, I must ask if you grant me permission to provide service process via email for any filings in these related cases. Thank you. P.S. Here is the training video made by your colleague explaining the records law.
Guedes. Regarding your request for email service, I have no objection to service by email in the Fernandez-Rundle appeal. I can't speak to other proceedings because I'm not involved in them.
McDonough. Counselor Guedes, thank you for your candor. However, when you fail to address my concern of your 30-hour delay in acknowledging my records request, I know you were reading my emails, and you were asking me for a favor. Once I said no, you ignored everything else, Please don't disrespect me by playing any more games. Without a valid response and justification for the unreasonable delay in immediately acknowledging my request, this is a 119 violation, period. I thought you would have watched the training video made by your colleagues, combine that with knowledge of your firm losing a 119 case against me just this past Monday due to their malfeasance, and further would have been so ashamed of me having to point out you were looking at the wrong rule of appellate procedure, so that you would subsequently follow the law to a T. For clarification, the request was to provide personal service to you, as I plan to amend my 119 complaint, naming you as a defendant. I was hoping you wouldn't dodge my process server the way your colleagues have, and would simply agree to accept process service via email to reduce the cost and time for all parties. Do you have a reasonable justification for the delay, and/or will you accept process service via email? 2. Additionally, you have not provided your bar number, either as was requested. Further, this is a public record, of which you would be in possession of, and failure to acknowledge or produce is also a 119 violation. I would appreciate you addressing these 2 points above.
Guedes. I've seen your email below and will respond to it later today. I've been out of the office since Wednesday mid-afternoon and am traveling today. In order to address part of this morning's email, your question regarding my Florida bar number, it's 768,103.
McDonough. Counselor Guedes, please explain why am I not the least bit surprised that you failed to respond, yesterday, as promised? That's a rhetorical question, by the way. Yet, I must still thank you for supplying your bar number, thereby tacitly acknowledging that it is a public record, and tacitly admitting that you violated 119 by refusing to provide or even acknowledge it in response to my clear request. After you acknowledged your understanding of my email as a 119 request, I even provided you the reasoning for the request, though not required by law. This on top of your unjustified delay in immediately acknowledging my request. I am going well over and above the minimal requirements and applying reasonable deference and or discretion here. I only ask that you at least make it to the minimal standards required by the law. For your convenience, I am providing the link to the 2017 Government in the Sunshine Manual, where all questions you may have regarding your documented violations of law can be answered quickly and succinctly. If you have arguments or case law against any parts of this manual, please provide them so this issue can be quickly and amicably resolved. Link provided. This is not to mention the bad form of writing to a proso without providing your bar number to start off with. I don't know you, and neither you, your firm, your colleagues, nor your clients are party to the suit, though indirectly interested. Do not forget you came to me asking for favors, while asking me to consent to waiving my rights. Then you refuse to follow the law after I clearly telegraph exactly what is going to happen. Come on, I also told you to read the rules, and you come back citing the wrong one, again forcing me to school you, and you have the certifications, not me. How would you be feeling, or what would you be thinking if you were in my shoes? Be honest with yourself. Can you provide one good reason not to think highly negatively upon such behavior? Seriously, who do you think you are? What connections do you have that make you so arrogant in your blatant malfeasance and ethical failings? The level of your connections and malfeasance place me in fear for my life and safety, as well as that of my family. Further, I would note that providing public records after being notified of pending litigation in which you are now a defendant does not moot the issue of the violation. I will likely be seeking mandamus against your actions. Then most certainly I will be seeking an injunction against your firm, colleagues and or clients for their malfeasance as well. As an aside, I must rightfully ask, were you trying to obstruct my criminal complaint against your client, Chief Alexander Roll, for official misconduct FSS 8380221AC, as well as perjury? I see no other reason to attempt to enter as amicus, other than possibly to attempt to obstruct my civil rights/state torts lawsuits. I would guess, however, it is actually quite a bit of both, and I'm positively certain of this. It must be noted, if any parties enter as amicus, then both the ACLU and the DOE will be requested to also enter. The former is already on board if it goes that far, while the latter has already entered in 2 other cases in Sharp v. Baltimore and Garcia v. Montgomery. Trust me, Google is your friend. If Homestead doesn't want recordings to occur in certain portions of their police department, they should be able to find competent counsel to draft reasonable time, manner and place restrictions. Yet, said restrictions would have to be tailored to a specific and legitimate government interest, while leaving open ample alternate channels of communication, and not overbroadly infringing upon protected speech, press or petition activities. Such restrictions would not, however, reasonably apply to a public lobby on public property upon which the public has free access to come and go at their leisure. C. Smith v. Cumming. Not sure any restriction would actually meet intermediate scrutiny, but you can always try. Practice makes perfect, they say. The current sign in the police station does not cut the mustard, so to speak, and you have an obligatory duty to in good faith inform your clients of this. I would prefer not to add any more First Amendment claims at this point, especially for another prior restraint claim. Additionally, enough taxpayer money has already been wasted on the totality of shenanigans here, wouldn't you say? When are your clients going to stop increasing the number of their violations? I thank you in advance for your efforts as a reasonable and prudent man in working towards this righteous and noble goal. In case you are wondering what I am talking about with the sign, here is an article I wrote on it, link provided. Back to the heart of the matter of your desire to enter as amicus. We both know, or should know, FSS 934.03 absolutely does not apply to my actions, and my recordings are already admissible. Further, we did not need the 11th Circuit to hold that, as it is already binding law in Florida, and provided for in the government in the sunshine mandates of our state constitution. I am trying to save tax dollars here, though your firm has a clear, transparent and repeatedly displayed financial interest otherwise. To such an extent I must remind you, your colleagues and your firm, that you have a duty not only to your city clients, but also to the citizens who you are actually working for. That includes fiduciary responsibilities to not waste their hard-earned tax dollars, and to limit liability while simultaneously helping your government client to actually comply with the law, and not acting to help them evade it. Your firm may soon be defending arguments as to why many of their clients would seek to hire in-house counsel, as was done in Islamorada, especially in light of overbilling allegations. If you disagree, please provide me with statute or case law citations which would suggest a public official conversing with members of the public in their official capacity would have an expectation of privacy, meeting the definition of oral communication under FSS 934.02. Please do this in light of the holding of State v. Inciarano or Stevenson v. State. You can find these cited in Miglett v. Flynn, a non-published case which did not address First Amendment implications, which dictates that Florida privacy law follows the two-pronged test from Katz v. U.S., which finds its roots in the plain view doctrine. I humbly and respectfully request you to please explain why government officials would have a greater expectation of privacy than a citizen, or even more than a lowly humble peasant such as myself. I also respectfully request any other statutory or case law precedent supporting your position that I am incorrect on any point herein. To quote Chief Roll talking about me, I do my homework. I will be patiently and anxiously awaiting your response. The best Catherine Fernandez-Rundle was able to come up with so far for the expectation of privacy argument was Roe v. Wade. I know I am still laughing myself. However, I am positive with your credentials you can do better. If you can provide such evidence as I only want the truth and justice, I will graciously provide my consent to you entering as amicus, so long as you follow every rule and requirement to a T. No exceptions or waivers will be granted whatsoever. It is well beyond time this issue gets settled nationwide once and for all. To this effect I actually pray she files a petition for cert to the Scottish and it is granted. What glory would be brought by such an occurrence? Irrespective of what happens at this point, that does not change nor dampen the admissibility of my recording criminally or civilly. Even if some people with authority and or your collaborators wish to think, hope, pray, or pretend otherwise. As a bit of gentlemanly advice, you should probably attempt formulating better strategies in the future before you pull the trigger on coming into the ring against an informed citizen who knows their rights. Granted, I only went to Suntan U Miami, and not the Ivory Leagues, but just saying doing your homework never hurts, and is always sound advice. With your Harvard education and vast experience, as well as your oh-so-lofty appellate board certifications, surely you can provide such evidence as apparently you plan to claim this. Alternatively, When you discover that I am right beyond all reasonable doubts in my allegations, will you then push with me and others to have Chief Roll and others prosecuted for their crimes against innocent citizens as well as police officers? Remember, you are an officer of the court, and we must consider your duty of candor towards the tribunal and such. Lastly, did you contact LaSalle, or did they contact you? Interesting questions and inquiring minds want to know, since you emailed me 5 hours before the petition was filed, and me as well as the UG, Jardin Pratt, on the case are in regular communication. Holy Mother of God, look at the unholy tag team against a citizen, right? Clue much? We are left wondering, is the SA retaliating against an innocent citizen with the backing of a corporation who is an adverse party? Or conversely, is a corporation who is an adverse party retaliating against an innocent citizen with the backing of the SA? Obviously either scenario is way out of bounds of decency and fair play, and I publicly call foul. There are no 119 requests herein, and you are not required to answer questions, but you are not looking too good right now, and further evasion does not help that image. I'm so far past being sick and tired of well-trained professionals playing fast and loose with the law at their advantage and my detriment, than playing stupid when I call them out on it, that I want to vomit in my mouth just thinking about it. Sincerely, Dr. James Eric McDonough, also known as Doc Justice. He that blows the coals in quarrels that he has nothing to do with, has no right to complain if the sparks fly in his face. Benjamin Franklin.